Oh, this stupid thing drives me crazy. It didn't record the last third of this, so I'm going to re-record it, the last few minutes. Don't worry, not too long. Okay, we're talking about Plyler v. Doe. Plyler v. Doe, the last remnants of the Warren Court, with an aging Justice Douglas, basically struck down a Texas law that said you couldn't have illegal immigrants in public schools because they weren't paying taxes. And Douglas said that is basically irrational. I don't know. I think it's great that illegal immigrants go to school here, but I don't know. Is it really irrational for the state to say no illegal immigrants? Anyway, very controversial case. The interesting thing is undocumented versus documented people in this country is not a what? A suspect class, right? Illegal immigrants versus regular people, right? Not regular people, you understand, versus documented people is not a class that the Supreme Court has recognized as a suspect class warranting strict scrutiny. You follow me? That's why they had to use the rational basis test. So there was a class, undocumented versus documented, but like age, wealth, your immigration status is not a suspect class. Remember, the Due Process Clause and the Equal Process Clause says no state can deprive any person. So undocumented people here in the United States are people protected by the 14th Amendment Due Process Clause and the 14th Amendment Equal Protection Clause, but education is not a fundamental right warranting strict scrutiny, right? How many people disagree with that? Me too. And undocumented status is not a suspect class that warrants strict scrutiny by the Supreme Court. Follow me? Okay, the mother of all equal protection cases. Brown versus Board of Education, 9-0. This was a Warren Court case. This is one of the first Warren Court cases. This is why Eisenhower said that him picking Warren to be Chief Justice was one of the biggest mistakes of his presidency, because he didn't like the Brown decision. Now, two classifications, right? Black kids and white kids being treated differently. A suspect class, meaning strict scrutiny. The Supreme Court said, we don't care what evidence you show us that those schools are the same in terms of teachers, textbooks, facilities. They still violate the 14th Amendment because segregated schools are inherently unequal. Got it? Inherently unequal. They talked about black kids being stigmatized and feeling inferior by having been shunted off to black schools. All right? Now, if you think about it, Brown effectively struck down all Jim Crow laws because the justification for Jim Crow was separate but equal facilities. And, you know, the precedent of Brown could be used to strike down any Jim Crow law case. You know, Jim Crow laws. By the way, Jim Crow laws were interesting because they didn't, it's not that they permitted restaurants and theaters and, you know, to segregate. They required them to segregate. In Alabama, you could not have a restaurant that mixed white and black folks. It was a crime. It was a crime to bury a black person in a white cemetery. You couldn't do it if you wanted to do it. So the Brown concept of separate but equal isn't enough to comply with the 14th Equal Protection Clause, equally would apply to those laws as well. Just understand that Brown there was lots of resistance in the South. It took over a decade for the federal courts and federal troops at times, the National Guard being called up to enforce desegregation. Understand these concepts. There is segregation de jure, which is by law, which would be Jim Crow laws, a law passed requiring segregation. And then there is segregation de facto, which is discrimination in practice, even though it was illegal. So Brown made discrimination illegal, so it was no longer de jure segregation, but it was de facto segregation for another decade. All right, you have to know these two laws, all right? These are two laws that deal with discrimination. You must know these. The Civil Rights Act of 1964 and the Voting Rights Act of 1965. Now, remember, back to your federalism lesson, why did Congress have to rely on what clause? The Commerce Clause. Why did it have to rely on the Commerce Clause for the Civil Rights Act of 1964? That was because it prevented discrimination by private citizens. Remember, the 14th Amendment says no state shall deny due process or equal protection. This applied to private citizens. So they couldn't use the 14th Amendment. They had to use the Commerce Clause. The Civil Rights, ironically, banned discrimination on the basis of race, color, national origin, and later gender. That was an amendment for discrimination where? In public accommodations. That's the weird twist. Private movie theaters and hotels are public accommodations. Go back to your federalism lesson and reread your notes on Heart of Atlanta, which was the high watermark for the Supreme Court using the Commerce Clause. When it wasn't even dealing with commerce, it was obviously dealing with race and discrimination. All right? So, Civil Rights Act bans discrimination of these groups based upon, at public accommodations or in employment. All right? Now, the Voting Rights Act. Congress could use the authority of the 15th Amendment because who runs elections and voter registration? The state. So they could rely on the 15th Amendment and say that's their jurisdiction. Now, burn this in your brain. The Voting Rights Act said you can't have discriminatory laws in voting. And the mother of all discriminatory laws that was still in effect prior to the Voting Rights Act was literacy tests. Literacy tests. Don't confuse literacy tests with poll taxes, which were abolished by the 24th Amendment. And you know what? I forget when I think the 24th Amendment was before the Voting Rights Act. Look that up and check that for me. All right? Okay. You know, it would have to be. Go double check that. Because the 24th Amendment was in the 60s also, probably the early 60s. All right? Okay, so I didn't write this, but no discriminatory voting or election practices. The law required states with a history of discrimination to submit their laws to the Department of Justice and get them pre-approved. The Supreme Court about 4 or 5 years ago said that provision is no longer constitutional with the passage of time. Affirmative action. This camera better not shut off again or I'm going to go crazy. Okay, affirmative action. Reverse discrimination. Bakke is not one of our 15 required cases, but the course outline is crystal clear. that affirmative action is fair game for you to be questioned on. So you need to know Bakke. All right, what is affirmative action? Affirmative action is whites being disadvantaged and discriminated against in preference of blacks. Now, this is only when it having to do with state facilities, state colleges. If it was a private school, I guess you could probably argue under the Civil Rights Act. But, so, does affirmative action, is it in violation of the 14th Amendment? Well, apply the analysis. Are there two classes that are being treated differently? Well, black students and white students. Is the classification based upon race? Interestingly, even though it was crystal clear that the 14th Amendment was adopted into the Constitution in order to protect black people, the Constitution, the 14th Amendment, has been interpreted beyond that. It's been interpreted to protect voting rights. What's the case? Baker v. Carr, right? And in the affirmative action cases, it has been interpreted to cover whites. So race is not just blacks being discriminated against in favor of whites, but whites being discriminated against in favor of black. All right, so the suspect class is race, even though whites were being discriminated against. By the way, whites call affirmative action, or if you are against affirmative action, you call it reverse discrimination. By the way, what's the justification of affirmative action? What? Strict scrutiny, compelling state interest, right? The state is going to say we have a compelling state interest in helping black people get on their feet. Whether you agree with this or not, it's pretty clear that black kids come from poorer communities, have poorer schooling, have parents that maybe haven't gone to college, and don't compete in getting into high-level state institutions. So, the University of Regents, the University of California at Berkeley, high-level public school, said we're going to admit, I think it was 17%, we're going to reserve 17% of our class admissions for minorities. Where did they come up with that number? They looked at the community they were serving. They said, well, about 17% of that is minority. We're going to reserve those seats. The Supreme Court said that is too broad. That is too broad. A quota is too broad a policy. Quotas are not permitted. But you still can use race as a factor for the purpose of achieving diversity in your school. Now, Grutter and Gratz, Grutter's, whatever the university, the undergrad case was, they struck that down because they were using a point system that basically amounted to it being a what? To being a quota, because all the minorities were getting in under their point system, right? In the law school case, they said that their use of diversity was fine. So, Bakke is still alive and well with subsequent Supreme Court precedent. All right, so an affirmative action case, you are going to talk about Bakke. You're going to talk about the rationale for affirmative action, right? Giving people with a history of discrimination a temporary leg up. Presumably over time, you'll start to have minority college graduates, and then their kids will be able to get in on an equal footing. Affirmative action was never designed to be a permanent fixture, just a fix to historical discrimination. All right? You're going to say it's going to be governed by the suspect class strict scrutiny test, because you are still making a distinction based upon race, even though it's not to protect blacks, but whites. You're going to apply strict scrutiny presumed constitutional. There has to be a compelling state interest, narrowly tailored to achieve its goal by the least restrictive means. And the Supreme Court says quotas violates this part of the test. But states still have a compelling state interest in achieving diversity in their state schools. All right, really quickly, Americans with Disabilities Act. This is a connection back to unfunded mandates and federalism. The Americans with Disabilities Act, Congress said, hey, states and private people can't discriminate against disabled people. Disabled people. Now, disabled people is not a group of people recognized by the Supreme Court as a suspect class, but Congress protected them under the Equal Protection Clause, right? Now, if you look up the Americans with Disabilities Act, the justification, Congress says the reason it had the power to pass it was because of the Commerce Clause. They had to put in the Commerce Clause because not only state buildings had to put in wheelchair ramps and state buildings had to, but also private buildings. The states had to fix their curbs for handicapped people. Why is it an unfunded mandate? Because Congress said, we have the authority to make you do this, private building owners and state buildings, because of the Commerce Clause in the 14th Amendment, and we are going to give you no money to get the work done. We're going to require it, but we're not going to give you money to retrofit, and if it costs more money to build a building like that, we're not going to give you the money to comply with the Americans with Disabilities Act. All right, got it? Hopefully this one recorded. Bye. Love you guys. You're awesome.